Hi, this is Robin Padgey, Training Coordinator at WorkLogic HR.
And I'm Katie Radis. I'm a partner in the law firm of BeldenBlaine and Radis, and I'm also the in-house counsel at WorkLogic Legal Solutions.
Today we're talking about preventing harassment, discrimination, and retaliation in the workplace. You are going to be required to take a short quiz following this webinar. Good news is that we are providing you with the quiz questions and answers throughout the webinar, so pay attention and that quiz will be a breeze.
The objectives of today's program are threefold. By the end of the seminar, we hope that you're able to recognize behavior that could lead to a harassment or a discrimination claim. Everyone knows the obvious stuff to look for. If you see a coworker getting groped or attacked in a coat room or something, you know that your radar should go up. What you need to be able to look for, though, are the things that are less obvious. Behavior that isn't quite as egregious, but could nevertheless lead to the same claim down the road. That's the first one. The second thing is that you need to be able to properly respond to harassment complaints. Very rarely do complaints come in with someone saying, by the way, this is an actual complaint. They come in sort of a disguised fashion where it's someone who says, gee, I don't like that person, or they bug me, or things like that. That's the kind of stuff you need to be able to recognize so that you can forward it to HR and we can make sure we take the steps we need to rectify that. And then finally, we have to be able to prevent inappropriate behavior going forward, whether that's retaliation or future harassment. The first step in being able to prevent harassment and discrimination claims is being able to recognize what the problem behavior is. Harassment can be devastating to everyone involved. That's because we're talking about huge sums of money that are potentially at risk. In fact, the average jury award is $1.8 million. That's a lot of money. Most of these cases will actually settle. But guess what? The average settlement award is $300,000. That is a lot of money to give away to a plaintiff, to an attorney, and so forth. So the idea is we want to recognize this behavior so that we can curtail it and protect ourselves. This leads us to our very first question in the quiz. Question number 1. If you are accused of harassment by a coworker, your employer can be sued, but you can't be personally sued. True or false? False. Okay, this is a strange area of the law because when we talk about harassment and retaliation, this is a very unique area of the law, and that's because supervisors can face personal liability. Typically, when you mess something up at work, you're not going to end up as a defendant in a lawsuit. That is not true in the case of harassment and retaliation. Harassing supervisors, retaliating supervisors can be faced with personal liability. What I mean by personal liability, I mean that your stuff is potentially on the line. Your house, your car, your chunk of money that you save for vacation, that's the stuff that's potentially at risk. And it's at risk for conduct that you either know is happening or that you should know is happening because it's happening under your watch. If you're the supervisor who turns a blind eye towards workplace harassment or workplace retaliation, you may end up paying a big cost for it. One of the other problems with harassment and retaliation in particular is that in California, we have the Fair Employment and Housing Act, and the Fair Employment and Housing Act includes a one-way attorney's fee provision. This means that an employee who files a lawsuit and is successful in that they prevail and win money is able to then recover their attorney's fees. And guess what? The attorney's fees are very expensive. I'll point you to the case of Munoz v. UPS. In that case, the plaintiff wins a little over $27,000. How much were the fees to win that little chunk of money? Well, they were actually $697,971.80. That's a lot of money. It's almost $700,000. This was upheld actually at the trial level and then on appeal. So that's what's potentially at risk. It's not just the amount of money you're going to end up paying for the underlying harassment or retaliation, but also coupled with those fees. That's what makes this so important, so critical.
What is the definition of harassment? A lot of people think that everything's harassment. You're bugging me. Well, this is the definition. Harassment includes any conduct directed at someone or about someone because of being in a protected class, which substantially interferes with his or her work performance or creates a working environment that is hostile, intimidating, or offensive. We are going to give you lots of examples of folks who've done things to meet that definition. But before we do, here's some quiz questions. Number 2. Harassment is illegal when it is so frequent or severe that it creates a hostile or offensive work environment. The answer is true. And a lot of people are confused by that because they think harassment is always illegal. Lots of courts have said that simple teasing and an incident here or there is not enough to meet the definition. So we need to look at the frequency. How often does inappropriate behavior happen? And we also need to look at the severity. How bad is it? And those things coupled together will determine whether harassment is actually illegal or not. Question number 3. Harassment only includes conduct directed at someone or about someone because of being in a protected class. The answer to that is true. Now, we haven't talked to you about the protected classes yet, and we will. There are 16 of them in the state of California as of this moment. But if you go back to the definition, that's what it says. Harassment includes any conduct directed at someone or about someone because of being in a protected class. Question number 4. A single incident can be sufficient to create a hostile work environment. That answer is true. As I said earlier, harassment is illegal when it is so frequent or severe that it creates a hostile work environment. A single incident can be severe enough to create a hostile work environment. An example of a single incident that met the definition of harassment happened at Oberlin College in Ohio. A female service worker in the cafeteria had a male coworker place his pelvic area against her backside. And the lower court that heard the case felt that that single incident wasn't enough to create a hostile work environment. But the Sixth Circuit Court of Appeals reversed their ruling, and they found that a reasonable jury could conclude that the physical invasion of her personal space was sufficient by itself to create a hostile work environment. That's pretty scary. One of the things that's also scary about it is that it took the college a long time, about 5 months, to finally do something about it. We're going to be talking to you about how to respond to harassment, and one of the most important elements of response is that it happen quickly. You don't wait 5 months to get around to finding out what happened.
So this takes us to question number 5. Sexual harassment includes unwelcome sexual advances, requests for sexual favors, and other verbal, visual, or physical conduct of a sexual nature. True or false? This is true. This is actually the definition of sexual harassment. Question 6. Sexual harassment is the only type of harassment that is against the law in the workplace. False. There are lots of ways to harass people. You can harass people based on any one of those 16 protected classifications. A little later in the program, we're going to talk about each one of those different protected categories. For now, know that they're all off limits when it comes to harassment.
Question 7. Sexual harassment has to include conduct of a sexual nature. The answer to that is false. Now, a lot of people think it's false because they think, no, sexual harassment could include verbal or visual. Well, if it's something verbal of a sexual nature or something visual of a sexual nature, then it's still conduct of a sexual nature. So the answer is false, but it's probably for a reason that you don't know. That reason is sexual harassment also is when people make fun of each other because of their sex. Men making fun of women for being women, women making fun of men for being men. Now, guys, I don't know if you make fun of women, but I know some women make fun of men. I was driving around town and I saw a car that had a bumper sticker on it that said, "Men are idiots and I married their king." That's making fun of men because of their sex. that would be considered sexual harassment. Now, the woman who was driving that car with that bumper sticker on it has every right to do so out in the world. But if she were an employee who was parking on company property, it would be in your best interest to tell her she needs to remove the bumper sticker. And if she refused, it would be in your best interest to tell her she cannot park on company property. Sexual harassment is also making fun of people because of their sex and in the form of a bumper sticker. So that kind of behavior is inappropriate in the workplace.
There are actually two different types of legal claims that you can bring if you want to bring a sexual harassment suit. The first one is called quid pro quo. And a quid pro quo suit simply means that someone has premised a employment benefit or conditioned your employment on the performance of some sort of sexual favor. If I told you you had to do a strip tease in order to get a job, or if I told you you were going to get fired unless you gave me a lap dance, these are the sorts of things that come up with quid pro quo. We've done a lot of training, and most people understand that this is not a good way to manage people, to hire people. I did have a situation not so long ago where someone was interviewing someone for an administrative assistant position, and he told her to stand against the wall, and if her chest touched the wall before her feet did, that she could have the job. This would be an example of quid pro quo harassment. Not only is it a really bad idea, it's also a really horrible hiring practice.
Another example of quid pro quo happened in the San Jose area at Tannemer and Antle, a lettuce grower and distributor there. The company was accused of allowing a female employee to be sexually harassed by her male supervisor. Specifically, he was asking for sexual favors in order for her to remain employed, and then constantly subjected her to unwelcome sexual advances. When she finally complained, he fired her in retaliation. The company admitted no wrongdoing at all, but settled with the Equal Employment Opportunity Commission for $1.8 million. Hostile work environment is the other form of sexual harassment, and this can be created by anyone. In quid pro quo, it's someone in a supervisory position to someone who's not, so they are abusing their power. But in hostile work environment, it can be anyone, coworkers, supervisors, vendors, customers. Anyone can create a hostile work environment by asking for sex, talking about sex, showing sexual pictures, etc. Hostile work environment can also be created based upon the other protected classes. Racial harassment can create a hostile work environment. Religious harassment can create a hostile work environment. So any of the protected classes can also be used to create a hostile work environment. Our example of a hostile work environment happened at the Department of Corrections in Chowchilla. What happened here was two female correctional employees claimed that they were subjected to sexual harassment, not because the warden was subjecting them to sexual advances, but because he was giving favorable treatment to three female employees that he was having consensual sexual affairs with. The warden's favoritism prevented the plaintiffs from getting promotions and caused them to be subjected to repeated harassment by one of the women that he was having an affair with. The trial court dismissed the plaintiff's claims, finding that the warden's favoritism did not constitute sexual harassment. Courts don't really care if supervisors have sexual relationships with their subordinates, and they don't even really care if they favor those subordinates because they're in a consensual relationship with them. However, in this case, the court found that because the supervisor was having sexual relationships with so many women, that he was sending the message that employees are sexual playthings and that the way to get ahead is to have sex with the supervisor. The court said that while sexual favoritism toward a subordinate may be unfair, it doesn't discriminate against men or women because both are disadvantaged for reasons other than their gender. However, if favoritism is based on consensual affairs and it's widespread in the workplace, both males and female employees who do not welcome the conduct can establish a claim for a hostile work environment. Discrimination occurs when a member of a protected class is treated differently, specifically because of his or her protected class. It happens a couple of ways. One way is unequal or disparate treatment, and that is when, again, people are treated differently because of being in a protected class. For example, saying that married people can have weekends off, but single people need to work. Marital status is protected. You can't treat people differently because of being in a protected class. Saying that Christians get to celebrate their religion at work, but people of other religions don't. That is treating people differently because of religion, which is a form of discrimination. The other type of discrimination is unequal or disparate impact. This is where people might not mean to treat people differently, but because of the nature of their policies or practices, that's what happens. It doesn't have to be intentional. It can be accidental. My father told me a story 40 years ago. He wanted to apply for a position in law enforcement. And at that time, he said that there was a policy you had to be at least 6 feet tall in order to apply. On his best day, he was not 6 feet tall. He couldn't apply. So could a whole bunch of other people not be able to apply. Women rarely reach 6 feet tall. Some people of color, Asians, Hispanics, rarely reach 6 feet tall. So a policy that says you have to be at least 6 feet tall in order to apply might not seem discriminatory on purpose, but it might have an inadvertent way of keeping people from applying for a job. Any kind of policy or practice that accidentally discriminates against people is also illegal. So that leads us to question number 8. Discrimination for any reason is against the law. And the answer to that is true, because discrimination occurs when a member of a protected class is treated differently because of being in a protected class. However, people toss around the term discrimination all the time, and they are incorrect in its usage. People say, you didn't hire me because of the piercings in my nose. That's discrimination. Actually, it's not, because piercings are not a protected class. You didn't hire me because of the tattoos I have on my face. That's discrimination. Actually, that's not, because tattoos are not a protected class, unless it's a religious tattoo, which we'll get to just a moment. So a lot of people think that anytime something works against them, they're being discriminated against. They're only being discriminated against when they are being treated differently because of being in a protected class. The next thing we'll talk about is relevant laws. When did harassment discrimination become against the law? That happened with the signing of the Civil Rights Act in 1964. Specifically, Title VII identified 5 classes that were considered to be protected. People could not harass or discriminate against people because of being in these 5 classes. And then California created its own law against harassment and discrimination, and that is called Fair Employment and Housing Act, or FEHA. And under FEHA, California has more additional state protections. California has more protected classes than any other state in the nation. And then AB 1825 is the law signed by Governor Schwarzenegger requiring that you attend this webinar today. So the specific requirement is that all employers with 50 or more employees provide supervisors with harassment training every 2 years. So if you want to avoid training, go to work for an employer outside of California or that has fewer than 50 employees. An example of the First Amendment not protecting everything that we have to say happened recently with Curt Schilling. Most people know he's a former all-star pitcher, and he was one of the highest profile baseball analysts on ESPN until he got fired. What happened was he was discussing on Facebook about the North Carolina law that bars transgender people from using bathrooms and locker rooms that don't correspond with their birth genders. And on his Facebook page, he posted a photo that showed an overweight man wearing a wig and women's clothing with parts of the t-shirt cut out to expose his breast. It says, let him in to the restroom with your daughter, or else you're a narrow-minded, judgmental, unloving, racist bigot who needs to die. To that, Schilling added, a man is a man no matter what they call themselves. I don't care what they are, who they sleep with. Men's room was designed for the penis, women's not so much. Now you need laws telling us differently? Pathetic. ESPN canned him for that Facebook post. They said ESPN is an inclusive company. Curt Schilling has been advised that his conduct was unacceptable and his employment with ESPN has been terminated. Curt Schilling had the right to post whatever he wants to on Facebook. ESPN has the right to fire him over posts that are derogatory and discriminatory in nature.
So there are three primary modes or methods of harassment. And what I mean by that are three different ways that you can harass people. The first is verbal, the second is visual, and the third is physical. Let's talk about verbal harassment. When I talk about verbal harassment, I'm talking about the things that you hear, the things that you overhear, the things in the workplace, and it might be derogatory comments or jokes or stories, nicknames. All of those sounds that come about in the workplace can form the basis for a claim. They don't have to be made up of words. It could be moaning or grunting or whistling or screaming. There are all sorts of sounds in the workplace that can be offensive and unwelcome. Radios, songs, music. I've had a lot of issues where you might have a radio station that's on in the background that's playing rap music. And that rap music may have all sorts of lyrics that are very offensive. Here's a takeaway lesson. Don't ever play a Nicki Minaj song in the workplace because every other word is the F word. There are lots of things like that, though, that you might not be thinking about. If you have music playing on in the background and somebody happens to overhear it, well, that certainly is something that could form the basis for a claim. We have some examples here: derogatory comments, slurs, nicknames. This is just a sampling of the things that are said in the workplace that can form the basis of a claim. There are a whole bunch of other things that you might hear in the workplace, whether it's something that someone's playing on their phone, whether it's a video clip or some other soundbite that can form the basis for a claim.
Hey, Katie, we had a client who had a supervisor whose cell phone ringtone said, "The INS is coming, the INS is coming." So I think he thought that was funny. Other people, not so much. And so they told him to change his cell phone ringtone. And so then that begs the question, may employers or supervisors tell their employees to change the ringtone that's on their personal cell phone? And the answer is yes, at work. And by the way, they can also tell them not to bring their cell phones to work. So some people don't understand that having a cell phone at work is a privilege, not a right. And if you abuse it, it can be taken away.
That leads to question 10. It's okay to make jokes about race, religion, sexual orientation, etc. if you are of the same race, religion, or sexual orientation. True or false? False. It doesn't matter if I'm in the same gender, race, religion, whatever protected group you want to choose. If I'm saying this joke to someone else, they, A, may be offended even though they're not saying that, but somebody else can overhear and they can be offended. That kind of joking and teasing is just not appropriate in the workplace. Question number 11. Nicknames such as calling older employees grandma and grandpa are permissible as long as no one complains. I heard a joke not too long ago and they said, well, of course they don't complain because they can't hear that we're calling them grandma and grandpa. This is not the kind of joking we want at work. I can tell you that age discrimination claims are on the rise. We have an aging workforce, a lot of people staying at work much longer than they would have historically. And so all those people in the workplace really don't want to be teased about how old they are. The answer to this question is false.
Now, I had a guy one time in training say that he was taught harassment is if he says something and somebody says, that offends me, and he says it again, and that's harassment. Yeah, except there was a Google court case where an older employee was called grandpa, old fart, old fuddy-duddy, and he didn't complain, but then they fired him They said for poor performance. He said it was because of age discrimination. Google settled that for an undisclosed amount of money. I would like to know how much that was. The thing is that people don't complain until they don't have a job anymore, and then they complain.
Yes, every employee is happy until they're not.
Question number 12. A group of women making fun of men is not harassment as long as no men hear them doing it. The answer to that is false. Just because a man's not in the group doesn't mean that one of the women won't be offended, or even worse. So a situation I was involved in once upon a time, a supervisor was talking to a group of guys, and this was a male supervisor, talking to a group of guys about people who abuse the workers' comp system. He didn't like these people. And to emphasize his disgust with people who pretended that they were sick or hurt and collected money, he made a gesture of a vagina in front of these guys. And so they then went and reported it to the only female he supervised, and she came over and reported it to us in HR, and then he got invited to come over and talk. He didn't understand the problem. He was a guy talking in front of a group of guys. So what was the problem? The problem was that he made a gesture of a vagina, which is a protected class. Sex is what defines us as male or female. And so he learned that just because you're with your own kind doesn't mean you can say whatever you want.
So question number 13. Talking about your sex life, or lack thereof, with your coworkers is allowable as long as everyone else is doing it. True or false? False. Do not talk about your sex life at work. First of all, no one believes you. Secondly, just because someone doesn't complain about harassment does not mean that it can't form the basis for a claim or liability down the road. One of the worst defenses you can march into court with is the "she liked it" defense. She loved these stories. She told her own stories. It's a loser every time for the employer.
A winner for the employee, though, was the "I only did it in order to get along with folks," the "go along to get along" story. And so a woman went to work in an auto body store, and the guys put up their porn. She put up hers. They told their sexual stories. She told hers. And then one of the guys went a little too far, and she filed a complaint with HR and then quit and sued. The employer's defense was, she did it too, so how can she sue us? Her attorney said the only reason she did it was to get along with the guys, and she won. So just because everybody's doing it doesn't mean that somebody won't win a lawsuit.
That leads us to question 14. Asking a coworker out on a date is considered to be sexual harassment. True or false? False. But if you ask the person out on a date every single day for a year, maybe you will cross that line. This is one of those gray areas. Employers cannot prevent employees from having relationships. That occurs in the workplace all the time. However, at some point, when someone says, "No, I'm not really interested in dating you," and the person persists, you cross over that line and enter the world where you're going to get sued.
There was a case where a male coworker kept asking out a female coworker over and over and over again, and the answer was always no. So finally she went to HR and said, "Tell him to stop asking me out." And that's one of the fun things about being in HR is you get to tell people that she doesn't like you, stop asking her out. So he did stop asking her out. He would just stare at her in the workplace. And she went to HR and she said, "Tell him to stop staring at me." And they said, "We can't prevent him from looking at you." So she filed a sexual harassment lawsuit against the company. The court found him stopping by her workstation and staring at her to be stalking her, and she won. So it's okay to ask somebody out, but if they say no, then the answer is no. Another way people harass others is visually. So what kind of things do people show that gets them in trouble? First is porn. How many of you watch porn at work? Oh, I wish I could see your hands go up. You might laugh, but lots of people watch porn at work. Most porn watching is done between 8 a.m. and 5 p.m. What else gets people in trouble? Cartoons, drawings, especially graffiti, photographs, especially if you're sending naked pictures of yourself, Gestures, such as making a gesture of a vagina. Emails, social media postings, texting. There's now something called textual harassment, and tweets. All of these things can be seen, and so that's what visual is harassment that is done by showing things to people. So question 15. Employees can't be disciplined for emails they send to their friends at work because those emails are personal. True or false? The answer is false. You can be disciplined for the emails that you send. And hopefully nobody thinks that anything they're sending electronically through their work equipment is private anymore. There should be no expectation of privacy whatsoever if you are sending things on your work-issued computer or phone. Question 16. It's legal to send sexual photos of yourself to your coworkers as long as it's done on your own time with your personal phone or computer. A lot of people think this is false, but the answer is true. Unless you're under the age of 18, it is not illegal to send sexual photos of yourself. Now, is it a good idea to send sexual photos of yourself to your coworkers? It is not. Even when it's done on your own time with your own equipment, what can happen is that you send a photo to a coworker who doesn't want to receive it. And then they bring it into the workplace and show it to their manager or HR director, and then it becomes a workplace issue. So anything that you do outside of the workplace that involves your coworkers can become a workplace issue if they don't like being involved in it.
You know, Robin, I think all photos at work should be banned. We had a client not so long ago that had a sales meeting, and the person sat in the sales meeting and he didn't like what was said. And so he left the sales meeting and went to the bathroom, and he went to the bathroom. Okay. And he had his phone with him, and he took a picture and he sent it off to the boss and said, "This is what I think of your marketing plan." Really? Yes, really. That's what people do with their phone when they have that capability of sending off that knee-jerk reaction, and it can really get you into trouble.
Indeed. Question number 17. You can't be fired for things you post on Facebook. True or false? The answer is false. You can be fired for things you post on Facebook. Everything that we're telling you that you can't say or do in the workplace, you can't say or do outside of the workplace when it involves your coworkers. So be careful of the things that you post on Facebook because those things could get you fired. An example of a Facebook firing happened in Maryland. A senior Maryland State Corrections official was fired after making comments on Facebook about being groped in prison by guards. His post said, "Visiting the prisons. Haven't been groped this much since the flight on the honeymoon. And this is just the guards." He was the Department of Public Safety and Correctional Services statistics chief, and his boss got a hold of that Facebook and fired him. He holds employees to the highest professional standards and expects them to act in a professional manner, a spokesman said. So should all employers.
One of the things that comes up a lot for me with my clients is the issue of somebody calls in sick, and then here comes their Facebook page when they've checked in at the Santa Monica Pier or Disneyland, and here's the picture of us at the beach. I thought you were out sick. When that information comes to the employer and it comes in secondhand, and I don't care how many people I've asked, would you ever tell on your coworker? They all say no. But guess what? Somebody always tells because the employer always knows, hey, they said they were sick. And by the way, they're actually at Disneyland with their kids. That information that comes to the employer, even though it's coming through a backhand channel, is certainly stuff that the employer is legally able to discipline the employee for. You're not allowed to call in sick under false pretenses.
Exactly. Well, a lot of companies have honesty policies and that you need to be truthful in the workplace, and that is not being truthful. And so you might not fire somebody because of what they posted on Facebook, but you can fire them for being dishonest.
So the third mode for harassing people is physical conduct. We've talked about verbal conduct. We've talked about visual conduct. When I say physical conduct, what I mean are actions you take in the workplace. Typically, you'll think about touching other people. Maybe it's the office hugger or somebody who brushes up against you. We've done enough training that most people understand they're not supposed to engage and interact with their coworkers in that way. But what we're seeing now are claims that are evolving along this line. So, for example, I had a client where he would go through the office and give everyone a high five. And he'd get to the girl at the end of the line, and she was a little bit of a germaphobe. She didn't want to touch somebody who had just touched everybody else in the office. She told him, yeah, I get sick a lot. I'm not really wanting to touch you now that you've got all these germs on your hand. And he continued to do that over and over again. And he said, well, one of these days I'm going to convince you. She ultimately filed a claim. It didn't turn into a lawsuit, but this was certainly a situation that could have been avoided. Nobody comes to work for the physical contact they get at work. They come to work for their paycheck. So the benefit and the camaraderie and the collegiality that you're fostering by touching everyone at work is minimal compared to the risk. You don't actually have to touch people at work, though. When we talk about physical conduct, it could be stalking, it can be staring, it could be blocking someone's movements. All of that sort of physical activity can form the basis for a claim.
I was told of a situation where a gentleman had lost his wife after 30 years, and he was experiencing panic attacks at work. And one of the things that helped him was for someone to hug him when he had these panic attacks. And he was in a supervisory position, and the people he was asking for hugs were in subordinate positions. And so that's a risky position to be in. And his employer found out about him asking his subordinates for hugs and warned him not to proceed any longer. And he experienced a panic attack, and he asked for a hug, and he was terminated as a result of that. So this is someone who had no sexual intent behind his hugs. And it's very understandable why he was experiencing panic attacks, and understandable that hugs helped him get through those moments. But that's just something you can't ask of your coworkers at work.
This leads us to question 18. Staring at someone can be a form of harassment. True or false? True. When I first started out as a lawyer, I worked for a law firm, and we had a very cute receptionist, and we had a client who brought in a whole bunch of business. And he would come in and look at the receptionist and say, oh, shucks, you look like you're tense. And he'd give her a back rub, and he'd play with her hair, and she didn't really love that. So she complained about it, and so he would come in then and just stare at her. And he really liked that receptionist. The staring was just as bad as the back rub. She eventually complained again, and by the time I left the law firm, the client no longer came in through the front door. They moved him, he came in through the back door, and he didn't interact with that receptionist any longer. Staring, just because it's not actual physical contact with the person, is just as bad as touching them.
I had a participant in training say, but what about the 7-second rule? I said, I don't know about the 7-second rule. He said, yeah, I was told by a buddy that you can look at somebody up to 7 seconds, and if you divert your eyes, then you can't get in trouble. Nothing like that exists. So I told him, get his harassment training from experts, not from his friends. Question 19. Sexual harassment almost always involves some form of physical contact. The answer to that is false. It usually does not. What is happening a lot now to make claims happen is visual. So, for example, I had a client who called me up and he said, Robin, I think I've got a problem. And I love it when phone calls start that way. So he explained to me that he had a female supervisor who was talking to a female subordinate about what it's like to date now. The supervisor had been married for 20 years and was out in the dating field again. And she said, it's so different now. One of the guys I'm dating sent me this. And she showed her subordinate her phone. On the phone was a picture of his penis. The subordinate did not appreciate seeing that picture and complained to management. And management said to me, this is just girl talk, right? They're talking about dating. Girls get to do that in the workplace, right? And I said, it's a supervisor showing porn to a subordinate who did not want to see it. And so that supervisor was removed from her position because of poor judgment. So that's one of the things that can happen when you're in a supervisory position. You're held to a higher standard. And if you do things that we're telling you not to do, then that can present a problem for you.
Question 20. In order for sexual harassment to occur, the harasser must sexually desire the victim. True or false? False. Sexual harassment has no requirement of sexual desire, sexual intent, sexual motivation. We had a case not so long ago that actually went all the way to trial, and it was based on a series of events, but the straw that broke the camel's back was you had an employee who was sitting in a car, and he was sitting in the passenger seat, and his supervisor opened the passenger door and said, "Will you hand me my lunch?" And the lunch was seated in the driver's side seat. And so the employee was annoyed with the supervisor and said, "Why don't you get your lunch yourself?" The supervisor said, "Fine," and attempted to climb over the employee. He slipped and landed in a way that was a little bit suggestive because his face was now in the lap of the employee. He grabs the lunch and leaves the car. This was an interaction that lasted all of about a half of a second, and yet it formed the basis for a claim. There was no sexual intent, no sexual desire. This was accidental conduct. But it occurred in the workplace, and certainly that is stuff that can form the basis for a claim. The supervisor ultimately won that lawsuit, but he won because he was able to show a whole series of other behavior that supported the fact that they did not condone that kind of behavior, that they addressed it, that they reported complaints, that they investigated that, and so forth. When accidental conduct happens in the workplace, and it happens every single day, you want to make sure you have that backup of training employees, reporting complaints, investigating complaints, and addressing these concerns. Question 21. Heterosexual men cannot be found guilty of sexually harassing heterosexual men because there is no element of sexual desire. True or false? False. As we mentioned, you do not need sexual intent or desire in order to form the basis for a claim. Any sexual conduct in the workplace, whether it's teasing, joking, name-calling, hazing the new guy because he's brand new, all of that behavior can form the basis for a claim.
Well, you talked about the case where the supervisor accidentally did a face plant, but situation that was on purpose was a case where a guy went to work at an offshore oil rig. Other guys would come up behind him and pretend to have sex with him. And that was on purpose. He didn't like it. And he complained to his supervisor, whose response was something like, "Man up," which is not the correct response. And so he did man up. He sued the company for sexual harassment. This was in the late 90s. And the lower court that heard the case said, these are all heterosexual men. So how can there be sexual harassment? But the Supreme Court said it's conduct of a sexual nature. It's unwanted. That's sexual harassment. So those guys went down in the history book as setting the precedent that heterosexual men can be found guilty of sexually harassing heterosexual men. We're still talking about recognizing harassment, and the question is, who can be the harasser? Anybody in the workplace can be the harasser. Supervisors usually are, and we're going to tell you about a lot of court cases where supervisors harass their subordinates, but the subordinate can be the harasser too. Independent contractors, so anybody who drops things off, who comes into the workplace to fix things, could be the harasser. That's the UPS person, that's the FedEx person, that's the plumber, that's anybody who comes into contact with your employees, including non-employee third parties, and that's usually your customers. After training one day, I had someone who is an owner of a bank ask me if he needed to say anything to a customer who said inappropriate things to the tellers there. And I told him, yes, you do. And he said, I'm afraid if I say something that he'll take his money out of the bank and go someplace else. And I said, well, if you don't say anything, your employees might sue you, and so you'll lose the money that way. So you need to choose. Who can be the victim? Supervisors, and sometimes supervisors are the victim of harassment by their subordinates. So harassment doesn't have to go down the food chain, it can also go up the food chain. But non-supervisors are usually the ones who are the victim. Temps can also be victims of harassment. So if you have temporary employees who are working through a temp agency, don't think that you don't have liability over them, because you do. And interns and volunteers were added to the list in 2015. So any of those folks can be the victim of harassment. And when you're in a supervisory position, your job requires you to make sure that no one harasses your employees and that your employees don't harass any of the other folks that they interact with. Question 22. The harasser is always someone in a position of power, such as an employer or supervisor. The answer is false. The harasser can be non-supervisors, independent contractors, non-employee third parties, such as your customers. Question 23. Only employees are legally protected from harassment. False. The other folks who are protected include volunteers, interns, and temporary employees.
Question 24. Employees cannot be disciplined for inappropriate acts that occur off the worksite during non-working hours. True or false? False. What you do when you're away from work can get you into almost as much trouble as what you do when you're at work. That's because a lot of times employees will let their guard down when they're away from work. I'm speaking in particular about holiday parties or the golf tournament. I don't know what happens on the back nine of a golf tournament, but it seems like all good judgment goes out the window. I would almost work for free, honestly, in January, because you come back to work and hear what everyone did at every holiday party around town. This is the time where you relax and you're talking to your coworkers that are your friends, and it's all comfortable, and you've had a cocktail or maybe 2 cocktails, and all of a sudden people start saying and doing things that they know that they're not supposed to do in the workplace. It doesn't matter that you're not actually standing in the office. If you're standing next to coworkers and you're at a work-sponsored event, you are still at work for all intents and purposes when it comes to harassment and retaliation liability.
So now we finally get to the protected classes. Question number 25. Which of the following is considered to be a protected class in California? The answer is all of them. We're going to go through each protected characteristic or class and tell you about harassment and discrimination court cases to tell you exactly what people are doing to get themselves sued. The first one we're going to look at is race, and this case was a steel plant called ArcelorMittal in upstate New York. Former employee Elijah Turley testified during a 3-week trial that for 3 years, his bosses sat by while his coworkers harassed him, writing KKK and King Kong lives on the walls, playing howling animal noises over the loudspeaker, hanging a stuffed monkey with a noose around its neck from his car, and even threatening his life. After 3 years of that, he sued. ArcelorMittal said that Turley's account was mostly accurate, that the employees had done those things, but they likened the verbal harassment to regular old trash talking. These are just guys talking trash to each other. Jury awarded Turley $25 million. A case of racial discrimination happened at J.B. Hunt, one of the largest transportation companies in North America. The company was charged with discrimination for not hiring a black applicant because of his criminal record. The company's policy with respect to hiring people with conviction records was found to be too broad by the EEOC. That federal agency believes that blanket policies that prohibit hiring people with criminal convictions is a form of discrimination against people of color. The EEOC recommends evaluating the nature and gravity of the crime, the time that has passed since the crime or conviction, and the type of job being sought before disqualifying somebody with a criminal record. Example of color harassment and retaliation happened at Applebee's in Georgia. A light-skinned black manager consistently made derogatory remarks to a dark-skinned black employee about the color of his skin, then fired the employee when he threatened to complain to headquarters. The EEOC sued, and Applebee's settled for $40,000. That takes us to question 26 on your quiz. In order for racial harassment to occur, the harasser must be of a different race than the victim. The answer is false. People of the same race do harass each other, and people of different colors but are of the same race do harass each other, and those are both against the law. Question 27. White people are protected from harassment and discrimination based on the color of their skin. The answer to that is true. Now, if you said false, let's make sure that you read the question correctly. White people are protected from harassment and discrimination, just like everyone else is. Some people think that that means that white people can harass and discriminate against people. That's not what it's saying. Now, some people may say that this is false because they think that white people are not protected from harassment discrimination. It's just people of color who are. When the Civil Rights Act was signed in 1964, race and color were two of the protected classes. And at that time, race and color primarily meant people of color, because at that time, white people did not need to be protected from harassment discrimination. Today, that's a different case, and everyone is protected based upon the race and the color of their skin.
That takes us to discrimination and harassment based on sex. Mercy General Hospital is a great example of how costly it can be to have workplace sexual harassment happening. In that case, this was a physician's assistant. She was awarded $168 million by a Sacramento jury. Before we get into the details of that case, I'd just like to point out that a jury in Sacramento isn't used to prices that you might see in LA or San Francisco or other areas where everything costs $1 million. This is a group of people that are very aware of the value of money, and they still gave her $168 million, a single plaintiff. This is not a class action. So what was it that happened that was so bad? Well, in this case, she complained to the HR department at least 18 times, and she was complaining about behavior that was especially egregious. There were comments about sexual fantasies, different escapades. I think at one point she was poked with a needle. Obviously, this is very bad conduct, but it gives you an idea of how costly this stuff can be. Worcester County is an example of sexual discrimination. In that case, we had female retail clerks who alleged that they were being paid lesser wages than their male counterparts, even though the male counterparts were doing the exact same thing that the females were doing. In that case, the county ended up paying $60,000 to resolve this suit. This case is especially important because we recently had the Fair Pay Act that went into effect in California. This is as of January 1 of 2016. The Fair Pay Act changed the law. We used to have a saying that said equal pay for equal work, and that's what the law was. Now the new law is equal pay for substantially similar work. Substantially similar is not the same as equal. What you need to look at is whether the skill set, the responsibility, the effort that is required is going to be similar to that of another employee. If it's not similar, you need to be able to justify that disparity. If the male employees are being paid more, there needs to be a legitimate business reason as to why that pay differential exists. Maybe it's based on seniority, maybe it's based on education. It just needs to be based on something other than sex.
The next protected class is gender. Gender is a sexual identity that someone has adopted. There are people who have male body parts consider themselves to be female. That is their gender. Female body parts consider themselves to be male, also their gender. Case of discrimination happened in Rapid City, South Dakota. The owner of Don's Valley Market there was sued by the EEOC. after he terminated an employee after she indicated her intent to present as a woman. He hired someone who presented as a male, and after going to work, the employee said she was going to present as a woman. Even though she was well performing, she had recently been promoted, the supermarket owner terminated her. The EEOC sued, and he agreed to pay $50,000 to the former employee. Case of sexual orientation discrimination happened in New York. Mirella Salimi was a chef and manager for Marianne's Mexican restaurant for 5 years in New York. She was a Catholic and a lesbian and claims that every Wednesday her boss, Edward Globokar, would lock the doors of the restaurant and force all employees to attend a 2-hour prayer service, during which Globokar and his pastor would declare homosexuality a sin. He also told Salimi on various occasions to be more effeminate, to get married, and to have kids, or else face eternal damnation. Salimi says that she asked Globokar repeatedly to stop condemning her sexuality and forcing her to attend services for a religion that wasn't her own. But Globokar allegedly retorted that unless she changed her orientation and attended church, her job was at stake. Globokar had to pay $1.6 million for discrimination against sexual orientation.
So you also can't harass or discriminate against people based on pregnancy. The next slide deals with step 3. This is a Hawaiian resort retailer, and they got hit with a lawsuit for firing a female retail buyer after she disclosed travel restrictions based on the fact that she was pregnant. How much did it cost them? $60,000. Pregnancy is one of those conditions that an employee may experience that requires an accommodation by the employer. We don't get to fire pregnant employees, even though they might cost us a lot of money or take time off. Linked to pregnancy is breastfeeding. Acosta Tacos learned this lesson the hard way. Marina Chavez worked for them as a cashier. She got pregnant, had a baby, and attempted to return to work when they said, sorry, we've gone ahead and filled your position. Later, they had another employee who called in sick. They called her and asked her to fill in. She came into work and then proceeded to breastfeed her baby in her car in the parking lot. The employer didn't like this. Ultimately, she gets told that she does not have a job and that she's not going to work there as long as she's continuing to breastfeed her child. This is a bad idea. The Department of Fair Employment and Housing sent Acosta Tacos a bill for more than $46,000 for having made that decision. California has very specific protections related to lactation accommodation for employees. The employee who is nursing a baby or would like to express breast milk needs to be provided with a place to do that, and it can't be a bathroom stall. It needs to be another private location where they're able to do that. I get questions all the time from clients that say, well, she's always off in that room with her breast pump. I don't care how often she wants to go into that room. She's allowed to do so. That's a California protection.
The thing about Acosta Tacos case is that I am sure the owner of that restaurant did not even know that there is a law about breastfeeding in California. And that's one of the unfortunate things, is that ignorance of the law is no defense. In 2016, more than 800 laws were signed into action. Not all of them were employment, but how is an employer supposed to keep up with all of the laws that they have to adhere to? They must find a way. Ignorance of the law, again, is no defense. I want to talk about marital status now, and I could not find a court case to talk about marital status, but I do have an employer who told me once that he likes to hire married men. They show up for work. He said single guys, they go out, they get drunk, they can't come to work. Married guys come to work. They don't want to stay at home. They want to come to work. I told him you cannot make employment decisions based upon marital status. So marital status is whether someone's married, divorced, widowed, or single. And our quiz question actually happened with a client. Telling a subordinate he needs to marry the woman he lives with in order to make an honest woman out of her is okay because it has nothing to do with work. The answer to that is false. With this particular client, he was conducting a performance evaluation, and at the end of it, he told his employee he needs to marry the woman he lives with. Problem with that is twofold. Number one, it's none of his business. Number two, if he fires that subordinate, the subordinate might have a claim against the company for marital status discrimination. Next protected class is religion, and this particular case happened at AT&T in Kansas City. Suzanne Bashir worked there for over 5 years when she converted to Islam and began wearing the clothing that Islam calls for, including a hijab. She said that for 3 years, her coworkers called her a towelhead, a terrorist, and asked when she was going to blow up the building. She complained internally a number of times, but nothing changed. One day, for some reason, her boss snatched the hijab off her head and exposed her hair. And then she complained to the EEOC. That agency sued, and the jury awarded her $5 million. A case of religious discrimination happened in West Virginia at Consolidation Coal Company. Beverly Butcher, who is an evangelical Christian, had worked at this company for over 35 years. And one day he came to work and there was a new time clock in the form of a hand scanner. Beverly informed management he could not use the hand scanner because of his religious beliefs. He believed that scanning his hand would give him the mark of the beast. And in case you're unfamiliar with that term, the mark of the beast is from the book of Revelation in the New Testament of the Bible. The beast is the Antichrist, and a mark is placed on the hand or forehead of his followers so they can buy and sell things at the end of time. You might have guessed having this mark is not a good thing. So Butcher requested an accommodation. And according to the EEOC, the company refused to consider any other way of tracking his time and told him he would be disciplined up to and including termination if he refused to use the hand scanner. So he retired instead. The EEOC sued, and the jury awarded him more than $500,000 in lost wages and benefits and compensatory damages. Employers must accommodate religious beliefs and practices if it's reasonable. And in this case, I'm sure the employer thought, this is crazy. This hand scanner is going to give this guy the mark of the beast? That's stupid. And so why do we need to accommodate it? It doesn't matter whether you believe in the same religious beliefs or not. Employers must try to accommodate the beliefs and practices of their employees if it's reasonable. And in that case, it would have been. Not only can employers not harass or discriminate against employees because of their religious beliefs, but they have the affirmative duty to reasonably accommodate an employee's religious beliefs and/or observations, unless doing so would result in an undue hardship to them. Some common methods of religious accommodation in the workplace have included scheduling changes. For example, allowing an employee to come to work early in order to leave early to attend religious services. Shift swaps, allowing an employee to swap shifts with another employee so as to avoid working on their Sabbath. Changing job tasks, relieving an employee of a task that conflicts with their religious beliefs, such as raising the American flag. Using the workplace for religious observance. For example, allowing the employee to use a quiet area for prayer during break time. And making exception to dress standards and grooming policies to take into account religious practices. Whatever the employee is asking for doesn't have to be accommodated if it is unreasonable, but employers are required to try to determine whether an accommodation can be made to eliminate the conflict between employment requirements and religious practices.
National origin is another protected characteristic. Delano Regional Medical Center learned this lesson the hard way. They were hit with a claim based on an English-only policy. English-only policies are not legal. We cannot require that all of our employees only speak English when they're at the workplace. In this case, it was Filipino Americans who complained. They said they were subjected to harassing comments and scrutiny and extra discipline based on the fact that they were speaking their native language or speaking with an accent when they were at work. Some of the things they alleged were that they were made fun of. They were told to speak English even when they were already speaking in English. They brought a claim, and ultimately, Delano Regional Medical Center settled that suit for $975,000. It would have been a lot cheaper to let them speak in their native accent and in their native tongue. Let's move on to ancestry. Washington State University Tri-Cities got sued because employees claimed that the director of student affairs called them names that were based on their ancestry, in particular Nip and Tokyo Rose. Those are derogatory terms for Japanese people, particularly during World War II. They also alleged that they were called Kunta Kinte, which is the name of a black slave from the book Roots, and they complained about various other behaviors in the workplace. Ultimately, the employee was awarded $100,000 based on these actions. Ancestry, just like national origin, is not something that's appropriate for comments, jokes, or other things in the workplace.
The next protected class is age, and this pertains to people who are 40 and older, which some people might find unfair, but when you get to be 40 and older, people don't want to hire you and they want to get rid of you. Such was the case in our court case. Dr. Pepper Snapple Group was ordered by a California jury to pay $18.3 million to 6 former employees who alleged the company committed age discrimination. The situation was these 6 employees worked at the Los Angeles bottling facility, and they claimed that they were assigned to do work that was physically demanding in an effort to either injure them or make them quit. Their lawyers said that the physical work led to some of the workers developing knee problems and hernias, which left them medically unable to do their jobs. Each of the employees had worked at Dr. Pepper Snapple for at least 20 years. One of the things employers need to be concerned about is making employment decisions about a group of people. If everybody in that group is 40 and older, there's a chance of an age discrimination claim coming. Medical condition refers to cancer and genetic illnesses. Charles Weidman worked for Acme Electric as Western Regional Sales Manager, and he developed kidney cancer in 2006 and then prostate cancer in 2007. His cancers required 2 surgeries and numerous cancer-related outpatient appointments. And the company was very good about granting his request for time off for the surgery and for recuperating. But then he requested further accommodation for the travel limitation his cancers caused. So he said he couldn't travel as much as he did before. This time, the company refused to grant or even acknowledge the accommodation request. Instead, Mr. Weidman's supervisor gave him an unfavorable performance evaluation and criticized him because he couldn't travel. Shortly thereafter, and failing to take into account that his performance had improved tremendously while he was recuperating, the company fired him. And they said the reason that they did it is because he couldn't do his job because he couldn't travel. California's Fair Employment and Housing Act, which is called FEHA, says that people with disabilities such as cancer have to be reasonably accommodated so that they can continue to work. And the Fair Employment and Housing Commission found that Acme Electric violated FEHA by refusing to accommodate Mr. Weidman's travel limitation and failing to engage in a good faith interactive process. They said they discriminated against him because of his disability and failed to take all reasonable steps necessary to prevent discrimination. So that's one of the things a discrimination claim can turn into a lot of claims. To compensate Mr. Weidman for his losses, the commission awarded him $748,000 plus change for lost wages, $22,000 for out-of-pocket expenses, $50,000 for emotional distress. And then they ordered Acme to pay $25,000 to the state's general fund as an administrative fine.
So we're going to move to physical disabilities. Physical disabilities and mental disabilities are 2 distinct categories. They're both protected. Tesoro Refinery learned that lesson. Michelle Daniel had worked for them for 18 years. She suffered an on-the-job injury, and that required knee surgery and then some follow-up treatment. The company decided they weren't going to accommodate that, and instead they terminated her. So she took her claim to the jury, and a jury gave her $8.5 million. This takes us to question number 29. Physical disability is a protected characteristic, which means that people with physical disabilities cannot be fired from their jobs for any reason. False. Just because you have a physical disability does not mean that you have a get out of termination free card. What a physical disability means is that it triggers an obligation on the part of the employer. When an employee or a job applicant, for that matter, has or is perceived as having a disability, the employer is then obligated to start the interactive dialogue process. This is a conversation you have with the applicant or the employee where you assess whether or not there might be a possible reasonable accommodation. Not all of the obligation falls to the employer. The employee or applicant needs to suggest possible accommodations or things that might work within the parameters of what their limitations are. But it's the employer's job to start that discussion. Mental disability, as I mentioned, another protected characteristic, is the next slide. I want to talk about the Valley Vista Services case. This was a $21.7 million price tag. It's an employee who had worked there for 7 years. She suffered severe panic attacks and asked for some time off based on those panic attacks. The company fired her after a month and said she had abandoned her job. Okay, wrong. She didn't abandon her job. She asked for an accommodation. Mental disabilities, I often get pushback from clients because the idea is that an employee or an applicant who is mentally disabled cannot possibly perform this job. But there are a number of jobs that people with mental disabilities can perform. And in fact, the American Medical Association continues to expand the definition of mental disability. There are lots of jobs that people with mental disabilities can perform. I work with a lot of lawyers, and I can tell you there are a lot of mentally disabled lawyers out there. Question 30. A person with a mental disability must reveal the disability during the job interviewing process. False. Employees and applicants are not required to reveal any medical condition, disability, or other limitation during that interview process. And employers are, in fact, not allowed to ask about those sorts of things. Question 31. Because employers cannot discriminate based on mental disability, job applicants who are impaired by conditions such as mental retardation must be hired. False. An employee still needs to be able to perform the essential job duties. If I am blind, I don't get to be a pilot. That's just the way it goes. If it's a mental disability or a physical disability that does not impede my ability to perform those essential job duties, I cannot be precluded from the opportunity to apply for that job or potentially perform that job.
Genetic information is your DNA. How would employers get it and why would they want it? How they get it is through a medical exam, and why they would want it is because your DNA can tell employers what illnesses you have or you might get. That happened at Loma Linda University. The medical center was charged by the Department of Fair Employment and Housing of having job applicants submit to a nerve conduction test to screen out those who had carpal tunnel syndrome. All applicants had already passed all their employment tests and interviews, and in some cases, some of the applicants had already attended orientation and were ready to work. Nonetheless, the hospital rescinded employment offers after some of the applicants failed the test results, even though there was no evidence they could not perform the essential functions of the job. The hospital settled for $259,000 plus change. It is legal for employers to have applicants submit to medical exams to see if they're physically capable of doing the job after they have offered them the job. But those medical exams only get to test their physical ability to do the job. It can't test what kind of illnesses they might have. Military and veteran status is our last protected class. Veteran status has been a protected characteristic nationwide for many years, and military status became protected in California in 2014. If somebody is serving in the military, how might they be working for you? Because we have folks who serve in the reserves. And one person that served in the reserves was Vincent Staub. He was required to attend occasional weekend training and 2-week training program during the summers. He worked at Proctor Hospital in Illinois, and he was fired in 2004 and later filed a lawsuit claiming that a supervisor was out to get him as a result of his being in the reserves. He said that she disapproved of him having to train so much and her having to work around his schedule. She said that his training consisted of a bunch of guys standing around joking and smoking, and so she got him fired. He was awarded $57,000 in damages at trial. But this case is interesting because the U.S. Court of Appeals said that it wasn't his supervisor who got him fired. It was the HR manager who fired him. And the HR manager apparently had no anti-military feelings. But then the Supreme Court reversed that decision using the cat's paw theory, saying that it doesn't matter if the person who fired him was anti-military. It mattered that the person who wanted him fired was anti-military. So again, it doesn't matter whether the person doing the firing is motivated by anti-military feelings. What matters is that the person doing the firing is influenced by others with anti-military feelings.
There are also protections that are found in Labor Code sections 1102 and 1101, and these protections relate to political affiliations. Specifically, employers can't forbid or prevent employees from engaging in political activity or from participating in politics or becoming candidates if they wanted to run for office. Employers also can't control or direct an employee's political activities or affiliations. I can't tell my employees which political party to root for or to vote for. You also can't coerce or influence an employee's political action specifically by threatening to discharge them or terminate them. Even though statute 1102 refers specifically to threatening to fire somebody, I would suggest that any adverse action that you take against an employee as a means to coerce political affiliation or action would be illegal. So now we've concluded talking about the protected characteristics. What we're going to move on to now is retaliation. And one of the important things to think about with retaliation is the fact that this can form a separate basis of liability. Even if there has been no harassment at all, if you retaliate or take adverse action against an employee who has complained or who has participated in an investigation, you can be on the hook. There's a funny joke that everything you learned in law school, you could have just learned on the playground. That's because a lot of our legal premises harken back to playground justice. For example, you snooze, you lose would be the statute of limitations. When we talk about retaliation, this is paybacks. I'm going to get you. If you do something to me, I'm going to get you back. And what the law says is that we're not allowed to pay somebody back or get them back for complaining about harassment, for participating in an investigation, for giving evidence in support of an employee who has alleged a complaint. The definition of retaliation is that it's any adverse action or punishment that's made in response to a complaint of harassment, discrimination, or other illegal conduct. The Wisconsin Department of Veterans Affairs gives us a good example of this. Gary Winstrom was an assistant administrator, and when a coworker brought a claim against their mutual supervisor, he signed an affidavit in support of the employee. Seemed like a good idea, except that then the employer decided to relocate him to a new work location that was 216 miles away. Instead of making that round trip 216 miles every day, he decided to quit his job and file his lawsuit. That was a smart financial decision because he was ultimately awarded $1.8 million.
Constructive discharge occurs when an employee's working environment becomes so intolerable that a reasonable person would resign. And the example I have here is The Late Show with David Letterman. You might remember that David Letterman went on air one evening and said, "I have had sex with women who work for me on this show." The reason he did that was because he was being blackmailed. Somebody knew that Letterman, who was married, was having an affair with a younger employee. And this person tried to blackmail Letterman, and instead of allowing himself to be blackmailed, Letterman just admitted on air. He didn't lose his show. He didn't lose his wife. He didn't lose his sponsors. Nothing essentially happened. The blackmailer ended up going to jail. But what does all of this have to do with constructive discharge? One of his former female writers, named Danelle Scoville, wrote an article in Vanity Fair about that time. And she said that she used to work there, and Letterman never propositioned her, but the atmosphere was so sexually charged that she couldn't stand it. Additionally, she said that females who were having sex with Letterman and other executives were favored, and all of that created a hostile work environment for her. She said in her article, "Did Dave hit on me? No. But Dave and other high-level male employees having sexual relationships with female staffers created a hostile work environment for her, and so she quit." She never told Dave why she quit. She didn't tell anyone except in this article. So she didn't file suit, and she didn't want to file suit. But it's an excellent example of what constructive discharge is, where somebody quits the workplace because of a hostile work environment. Question 32. If you're a victim of harassment or discrimination at work and decide to quit instead of filing a complaint, you cannot later successfully sue the company for the harassment or discrimination. This is both true and false, and so you're going to get this question right whichever way you go. It's true for the following reason. One of the defenses that employers have when it comes to harassment complaints is that I didn't know about it. How can I fix something that I did not know? And so if an employee does not take advantage of an internal complaint process and put somebody on notice that something is happening that they don't like, how is the employer supposed to fix it? So in many cases, employees need to take advantage of an internal complaint process, and if the employer doesn't fix the situation, then the employee quits, then the employee files suit for constructive discharge, then the employee wins.
This is also false, though, Robin. In a lot of cases we've seen where the employee never actually voiced a complaint. And I have employers and clients that call and say, "Why am I on the hook for this? I would have fixed it had I known about it." What the court is going to look at is whether you knew about it, okay, they didn't know about it, or should have known about it. And when they look at whether you should have known something, they're going to look at the office culture, the work environment as a whole. They're going to dig through your computer to see what kind of emails you're sending out. What text messages are you sending? What other people in the workplace can come forward with derogatory comments and dirty jokes and all sorts of other things that you've done? What did you do at the Christmas party last year? All of that behavior can come in to show the type of culture that is going on in your workplace. If you are a supervisor and you're engaging in that behavior, you are sending a tacit message to every single person underneath you that this is okay. An employee who works in that environment can later come back very easily and say, "I was afraid to complain. I was afraid to raise this as a concern. I went along with this bad behavior so that I could keep my job." Question 33. If an employee complains of harassment or discrimination, that person cannot be fired for any reason. True or false? This is not a trick question. The answer is false. Complaining about harassment or discrimination or retaliation is not a get out of being fired free card. Employers who want to discipline people based on legitimate performance-related issues are certainly free to do so. If an employee marches into a termination meeting, and generally they know they're coming into a termination meeting when you tell them to come meet with HR at 5 p.m. on Friday, they often start that conversation with, "By the way, I've been harassed for the last 6 months. That's fine. We'll go ahead and look into that harassment complaint. It does not insulate them from whatever disciplinary action you are going to take. What is key is that you have a file that will support that disciplinary action, but it does not mean that you can't actually take that. It doesn't alleviate your burden to go back and investigate whatever they've alleged, but it also doesn't mean that you can't take whatever action you're already prepared to take.
Question 34. The standard to determine whether someone has been harassed is whether they feel they've been harassed. The answer to that is false. Now, a lot of people think that if I feel I'm being harassed, I'm being harassed. And the reason for that is that people like me tell them it doesn't matter what the intent of your behavior is, it matters what the effect of your behavior is. Having said that, that is not the standard. If everyone who felt they were being harassed was being harassed, then everybody would win their lawsuits. The standard is what a reasonable person thinks is harassment. Generally, courts use the reasonable person standard to define subjective terms. What would a reasonable person think? Investigators like me use that standard during our investigations. If we think a reasonable person would find the behavior that we've discovered to meet the definition of harassment, then we advise the employer to take certain action. And if we think it doesn't meet the standard, then we advise otherwise. Jurors are instructed, would a reasonable person think this behavior is harassment? And if the jury thinks that it does meet the definition, then you're guilty. And if they think it doesn't, then you're not. There is no list that says if you do this, it's harassment, and if you do this, it's not. Nothing clearly defined like that exists. So determining what a reasonable person would think is what the jury does. By the way, there's no test of a reasonable person to get on a jury, and there's no IQ test either. You don't want people on juries to make decisions about you. Some courts have said, because women are different than men, if a woman feels she's been harassed, the standard is what a reasonable woman considers to be harassment. And if I were a man, I'd be scared silly over that. No joke. I know that men and women tend to take things differently. And sometimes women are offended by things that men don't think are offensive. Guys, how many times have you said something to a woman and she's offended and you have no idea what you said that was offensive? Probably happens quite frequently. So how is a guy supposed to prevent himself from being accused of sexual harassment by a woman when he has no idea what a reasonable woman would find offensive? I think it's fairly easy. Don't talk about sex. Don't ask for sex. Don't show sexual photos. Keep your eyes at eye level. Keep your hands to yourself. And that should pretty much do it. And some courts have said that because people in different protected classes are more sensitive to things than others, if a person has been harassed, the standard is what a reasonable person in that protected class would think is harassment. I'm sure that was very clear. Let me try to clear it up. If a Muslim feels that he has been harassed, the standard would be what a reasonable Muslim considers to be harassment. And if a homosexual felt that he were harassed, the standard would be what a reasonable homosexual would consider to be harassment. Again, if you are not Muslim or if you are not gay, how would you know what people are sensitive to if they are in those protected classes? You can't. So how are you going to avoid lawsuits by people who are different than you? Again, I think the answer is easy. Don't joke about the protected classes. Don't ask questions about it. Don't have nicknames about them. Don't do anything involved with the protected classes. If you stay away from them, then chances are you can avoid lawsuits.
So, up to this point, we've been talking about recognizing harassment. Now we're going to talk about responding to it. What do you do? We've told you all these things to look for, whether it's protected classes, retaliation, other bad behavior in the workplace. What do you do if you actually see this happening at your workplace? It's very easy: reporting, investigating, and implementing. That's all we need to do. Why is it important? Why do we care about responding to harassment? It's because this is a separate basis of liability. What I mean by that is, even if there's no harassment that's actually occurring, but a complaint comes in and you fail to respond to it, fail to investigate it, you can be on the hook for that. I have had situations where were able to demonstrate that no harassment had actually occurred, and yet the client was on the hook later because they hadn't conducted a proper investigation. It's a separate basis of liability, so we need to pay attention to this piece. Reporting. This is the first piece of the responding. What needs to be reported? Everything. Everything needs to be reported. Complaints that come in from people who don't want you to tell anyone. Complaints that come in a disguised fashion, as in, ew, I don't like that guy, or she's crazy. This is how people talk in real life. Those are the kinds of comments where your radar needs to go up. You understand that this is something that might need to make its way up the food chain and get reported to HR. Who do complaints get reported to? Ideally, you would have more than one reporting option, because if you only have one person in the organization that employees can report to, lo and behold, that will be the person that is accused of harassing people. Employees can report to any supervisor. They can report to their own supervisor or to anybody else who is in a supervisory position. The important piece is that when a complaint comes in, whether it comes in a backhand fashion, whether it comes in with a request to not tell anyone, that complaint makes its way back to HR so that it can be investigated and addressed.
A very important part of reporting is documenting. One of the things that supervisors cannot do is require people who want to make a complaint to write it down themselves. That has been seen as a way to stifle the complaint process. If people can't write, then they can't complain. So supervisors need to document who told them, what they told them, when it happened, where it happened, witnesses that might be involved, anything that can help HR or the investigator with the situation. Supervisors, when the complaint is about you, the biggest thing that you cannot do is retaliate against people for making that complaint. And retaliation is usually in the form of messing with people's money, demoting them, transferring them, reducing their hours, firing them. But retaliation can also be just changing the working conditions of people. And one of the ways that supervisors change the working conditions of people is that they refuse to interact with them. That's a natural response when somebody complains about you, is to refuse to interact with them. You can't do that. You have to continue to interact with them on a professional basis. And then finally, confidentiality of the complaint process is limited. So if somebody comes to you and says, I want to tell you something, but I don't want anyone to know that I told you, you cannot promise them that no one will know. Usually during the investigation process, the name of the complainant is revealed because of the nature of the investigation questions. You can't just ask in an investigation, have you ever harassed anybody? That usually doesn't get an affirmative response. The investigation questions have to be very direct and pointed. Did you call so-and-so, such and such, in the break room yesterday? And when you ask questions like that, usually the complainant's identity is revealed. So you cannot promise confidentiality. As was previously mentioned, how you respond is paramount to what happens next. The response can make court cases go away. The response can increase the damages. An example of a good response happened at Erie Foods International. Tremaine Porter Black employee was walking through the warehouse and saw a noose hanging from the ceiling. He went and told his supervisor about it. She immediately got the noose, took it into her office. Now, unfortunately, she hung the noose up on a bulletin board, which wasn't a great thing to do. But she took the complaint seriously. She called HR. There was an investigation. And the employees that worked that shift said they didn't know anything about the noose. So they asked Porter if he would like anything else done. And then other incidents happened. And then everybody was put on notice that harassment would not be tolerated. And it went on with incidents happening and HR following up with investigations and reprimands and that type of thing. And then Porter quit. And then he sued. He said that Erie Foods did not protect him from racial harassment, that the noose was directed at him because of his race. Erie Foods said, "We took his complaint seriously. We responded immediately. We did an investigation. It was inconclusive. We told people this was a form of harassment that would not be tolerated." Porter said he was okay with how everything was handled. And the court said, well, you messed up on putting the noose on the bulletin board in the supervisor's office, but other than that, you responded appropriately, and so the case was dismissed. An example of a bad response happened at Baker & McKenzie, which is a law firm that has offices in 30 different countries. Martin Greenstein was an attorney in their Palo Alto office. Rena Weeks was Greenstein's secretary for about 3 weeks. One day, as they were leaving a departmental lunch at Sizzler, Greenstein dropped M&Ms into the pocket of Weeks' blouse and touched her breast. Then he held her arms back behind her, thrust her chest forward, and demanded to know which of her breasts were larger. After other similar incidents, Weeks complained to management, and they transferred her to another attorney. A couple weeks later, she quit and sued. She worked for the law firm for 6 weeks. During the court case, it was determined that Greenstein had previously harassed at least 10 other secretaries under his supervision in 2 Baker & McKenzie offices over a 6.5-year period. And the firm was accused of tolerating his behavior. And so the jury awarded her $7.2 million. Question number 35. Employers must investigate all claims of harassment unless the victim requests that no investigation take place. The answer to that is false, because the first part of that question is true. Employers must investigate all claims of harassment, regardless of what the victim wants. And the reason for that is because if the victim later decides that they wanted an investigation and they put the employer on notice that something had happened, the failure to investigate will count against the employer. Question 36. Harassment claims do not have to be investigated if the employee never files a formal complaint. The answer to that is false. Courts don't recognize the difference between a formal and informal complaint. Sometimes people think a formal complaint is one that's in writing, and an informal complaint is simply verbal. Not true. Any kind of putting the employer on notice is considered to be a complaint.
This is an important point, Robin, because most of my clients have a policy in their handbook that says if you have a complaint, submit it in writing, send it to HR, make a copy, all sorts of procedures that are set out. Those are great to have, but if the employee does not, in fact, avail themselves of that particular process, that doesn't matter with respect to whether or not their complaint might be valid. It's still a complaint. It still needs to be investigated. It still needs to be responded to.
Question 37. You must make complaints of harassment or discrimination to your immediate supervisor. The answer is false. You cannot make employees follow the chain of command on this, because if it's their immediate supervisor who's doing the harassing, that stops the complaint procedure. You must allow employees to make complaints to anyone above them in the food chain. Question 38. If you complain of harassment, your identity cannot be revealed during or after the investigation. The answer to that is false. Your identity will most likely be revealed during the investigation because of the nature of the investigation questions. Question 39. If you falsely accuse someone of harassment, you can be fired and/or sued for defamation. The answer is true. It's difficult to prove that someone filed a false complaint. Frequently in investigations, they're inconclusive. You don't know what happened. A lot of times it's a he said, she said, or she said kind of situation. And investigations sometimes are inconclusive. That does not mean that somebody did not harass somebody. Just because you can't find evidence doesn't mean it didn't happen. However, there are people who have filed false complaints to get people in trouble. And if it's determined that somebody made a false complaint, they can be fired and sued for defamation.
I want to talk about implementing investigation results. As Robin just mentioned, most of the time you won't know what exactly happened, but in some cases you are able to determine what precisely transpired between these two employees. In those cases, you're going to want to assess and determine the corrective action you want to take. Things you're going to want to consider: how egregious was this conduct? What was the harasser's employment record? What kind of discipline have you imposed in other cases? Do you have a progressive discipline policy that's in place? These are the kinds of things you'll want to consider as you determine what sort of corrective action is appropriate. What I'd like to highlight, though, is that 9 times out of 10, you won't be able to determine what exactly happened. That's all right. We can't go back in time and be a fly on the wall. I wish I could. It would be very interesting to see what actually did transpire. In those cases, you still need to take action. And you need to take action in order to prevent the likelihood of that conduct happening in the future. If you have 2 employees who are in a dark storeroom and one says that this happened and one says that it didn't happen, here's a solution. We're not going to allow employees to go into the dark storeroom alone. We're going to install cameras. We're going to take whatever steps are necessary in order to prevent this type of behavior from happening going forward. Question 40. If you have been harassed at work, your employer must fire the person who harassed you. False. Lots of times you'll do investigations where the victim has predetermined what the appropriate corrective action is. Those sorts of decisions are left to management. Victims do not get to decide what is appropriate or not appropriate for a given set of circumstances.
One of the things that employers should do, though, after an investigation is to let the complainant know that the case has been resolved, and if there's any other harassment that happens, to let the employer know. The employer can't tell the complainant what type of discipline was imposed upon the other employee, but the employer should tell the complainant that the case has been resolved, and if anything else happens, let them know. The final step in the process is trying to prevent harassment from happening. If you get hit with a claim, you want to be able to demonstrate that you have been trying to prevent harassment from happening the entire time. Here are some things that the company has to do. They need to have a poster on the wall that says harassment is forbidden. That poster needs to be where every single employee can see it. If you have employees who are more comfortable speaking a different language, and at least 10% of your workforce does, then you need to have the poster in that language as well. You need to have a policy in place that says this is what harassment is, it will not be tolerated, this is what to do if you feel you're being harassed, and you will not be retaliated against. An information sheet has to be given to every new employee, in addition to the employee handbook, if you have one, that says harassment is forbidden. It needs to be a standalone piece of paper that is given to every new employee upon hire. You need to have a well-communicated complaint procedure. Everybody needs to be able to know if you feel you're being harassed, this is who you should go to. And you need to have more than one person that they can complain to. An impartial investigation procedure. We didn't talk about how to investigate harassment in this series because most of the time supervisors don't do investigations. If you're going to have somebody investigate, which you need to, that person needs to be trained and impartial. That means they don't have a dog in the fight. They're just there to find out what happened. And so usually supervisors are not the ones who are investigating. Remedial action needs to be taken. As Katie said, you need to consider various things in determining the appropriate corrective action, and you need to demonstrate that people are being trained. So here you are conducting your training, and you can check that one off the list. That's what the company needs to do. What supervisors need to do are the following. If you see or hear inappropriate behavior, stop it. Don't allow it to happen. If you allow it to happen, you can be personally sued for the harassment. Again, you don't have to harass anyone to be sued for harassment. When you're in a supervisory position, if you know about it and do nothing about it, you can be liable. Take all complaints or incidents seriously. I had a situation where I conducted harassment training for a client and then got a call back to come back about a month later. One of the supervisors who had been in the training had received a complaint of harassment, and he didn't take it seriously. He thought the complaint was stupid, so he didn't report it to his manager. The employee who complained to him then complained to the manager and told the manager she had told her supervisor and nothing had happened. The manager said to the supervisor, "Why didn't you tell me about this?" He said, "I didn't think that it was anything to be concerned about." Supervisors don't decide that. So tell every complaint, send it up to HR or your supervisor in order to make sure you're doing what you need to do. Respond immediately. So again, tell your supervisor, tell HR, don't sit around on it. I had a participant tell me he got fired because he didn't tell anybody for 2 days. An employee had gone to him, made a complaint of harassment, but said, "Don't tell anyone." So he didn't for 2 days. In the meantime, the employee went to the HR manager and told her about it. So on day 2 of him not telling anybody, the HR manager summoned him to her office, asked him if he knew about the complaint. He said yes. Was questioned, "Why didn't you tell me about it?" He said, "The employee told me not to." He was fired as a result of having that information and not forwarding it. Document what happened. As we said, documentation doesn't need to be anything that's onerous. Just who told you, what they told you, when it happened, where it happened, put your name and date on it, and send it up. Don't promise no one will know who made the complaint. Don't promise that you're going to get the person that they're complaining about. Just promise that you will take the information to the appropriate person. And don't get back at the person for filing a complaint or let anybody else do so. One final thing that we need to tell you about before we close is new law about abusive conduct. Abusive conduct is another term for bullying. Bullying in the workplace is not illegal at the moment. What is illegal is for us to not tell you about it. So abusive conduct is conduct of an employer or employee in the workplace with malice that a reasonable person would find hostile, offensive, or unrelated to an employer's legitimate business interest. Abusive conduct may include repeated infliction of verbal abuse, such as the use of derogatory remarks, insults, and epithets, which is nicknames, verbal or physical conduct that a reasonable person would find threatening, intimidating, or humiliating, or the gratuitous sabotage of undermining of a person's work performance. So that's what bullying is. Now, we see a lot of common words here. We see reasonable person, we see verbal abuse, we see derogatory remarks, insults, all of those types of things that we saw in the definition of harassment. What is not in this definition of bullying is the protected classes. So while we took pains to explain to you that harassment is conduct directed at someone or about someone because of being in a protected class, abusive conduct has nothing to do with the protected classes. As we said, This is not against the law yet, but we're required to tell you about it, probably because it's going to be against the law soon. If people tell you that you are threatening, intimidating, or humiliating, now is the time to change your management style.
So, did you learn anything? What if your best employee has alcohol at work, has naked pictures on the wall, displays prominent religious symbols? All right, well, I'll let you take a look at that. That's actually my office. That's how I know it's the best employee. There are naked pictures on the wall. There is a bottle of wine on my desk. There is a cross. Not everything in the workplace is going to give rise to a lawsuit. There is an overlay of common sense. What this program is designed to help you identify are those areas where you can get into trouble. Not everything that happens at work is going to require that we call the FBI in or that we do an investigation, but you need to have your radar up. You need to be on the lookout for this stuff because it's very costly and these claims are on the rise.
In conclusion, employers and supervisors must create and foster an environment that promotes healthy working relationships. And hopefully, we provided you with the strategies to do that. First, employers and supervisors must be able to recognize harassment, both actual and potential. In doing so, remember the protected classes. It's not only sexual harassment, but racial, religious, anything based upon the protected classes could be harassment. Employers and supervisors must respond properly to suspected harassment. We told you how to do that. The response, there needs to be reporting mechanism in place. There needs to be a impartial investigation that's done by a trained investigator, and there needs to be implementing results. Determining the appropriate corrective action, making sure that people are disciplined consistently and fairly. And finally, employers and supervisors must take all reasonable steps to prevent future harassment. We talked about needing to have a poster on the wall and policies, information sheets given to new employees, remedial action and training. And supervisors specifically, remember that if you know about harassment and do nothing about it, you could face personal liability. So protect yourself. If you see or hear anything inappropriate, stop it. Make sure that you pass any complaints up to your supervisor or HR immediately. Make sure you document. Don't promise confidentiality, and especially don't retaliate or let anyone else get back at the person for making the complaint. All of this sounds pretty scary. It's basically very easy. People have the right to go to work without being harassed. Unfortunately, people harass each other. That's why it is the employers' and supervisors' responsibility to make sure that everybody can just go to work and get their work done and go home and take care of their families. This concludes our training. You have a quiz in your immediate future. So please log in to the website that is listed and complete that quiz. And if you have any other questions or concerns about harassment, discrimination, or retaliation, feel free to contact Katie or me at our contact information listed on the screen. We work at WorkLogic HR, a human resources outsourcing company that not only provides training for supervisors and employers, but a variety of human resources needs. We look forward to hearing from you, and good luck.